If you thought the oral argument in front of the United States Supreme Court on December 1st in the Dobbs case was about abortion or was about the Constitution, then you're mistaken. There's a very telling comment by Justice Barrett on page 45 of the transcript that I'll read to you and explain why the words of the Constitution and the Constitution and abortion were not the issue that the court will really decide. And here it is. Justice Barrett makes this statement after thinking about other important Supreme Court cases that have been reversed over time. And she said, in thinking about stare decisis, now I've done a whole series of podcasts at God, Law, and Liberty on this doctrine of stare decisis. It's an abbreviated Latin expression for things that have been decided should remain decided, to let them stand. She says, in thinking about stare decisis, which is obviously the core of this case. And there you have it. The core of this case is not what do the words of the Constitution mean. It's not whether or not the Constitution is supreme. It's about this doctrine of stare decisis. Now, you can get a concordance and you can go all through the Constitution and all the amendments thereto, and you will never find the word stare decisis. It's not in the Constitution, nor is it even logically required by any words in the Constitution. Why then would stare decisis be the core of the Dobbs case? And here it is. You see it throughout the comments by Sotomayor, Kagan, and Breyer. The credibility of the court. You see, the court uses this doctrine called substantive due process to infuse into the 14th Amendment rights that it thinks people ought to have, and then uses the doctrine of stare decisis to protect those judicially created rights from being attacked on the grounds that, well, we've already decided this, and we should allow it to remain decided, even if the original decision was wrong. And in fact, Justice Barrett goes on to say that. Is there a distinct set of stare decisis considerations applicable to what the court might decide is a watershed distinction? Now, what's he saying? Well, some decisions the court makes are watershed decisions, like finding that separate but equal is allowed by the Constitution was a watershed decision. And then Brown versus Board of Education, that over 70 years later is reversed Plessy, was a watershed decision. So she's saying when we have a decision that comes out of the blue from nowhere, makes some fundamental decision that changes the landscape of things, should we have a special set of rules other than did we interpret the Constitution right or wrong? When that begins to happen, you see that what has happened is the Supreme Court is putting its precedents above the words of the Constitution, which necessarily puts the Supreme Court above the Constitution. And when they've put themselves above the Constitution, to say that they've done something wrong when it was such a momentous decision is to impair the integrity of the court. And that's why Clarence Thomas, in Gamble versus United States in 2019, said that the way the court applies the doctrine of stare decisis is to provide a veneer of respectability to its decisions. That's what the Dobbs case is about.